Welcome, everyone. We're happy that you've made time to join us. This is our second in a series of issues that we'd like to present concerning estate administration. Joining me is Per Oscarrson and Sarah Smith. The three of us head up our planning and administration group here at the firm. And today, what we'd like to talk about is the process of probate. Now, before we get into the detail of it, let me mention a couple of things. First of all, even if you're not that interested in the process of probate, uh, for the sake of the administrative issues we'll discuss, you should be interested as estate planners. If you understand that the plan that you engage, either in your will or your trust or whatever other form of planning you might engage in, is implemented through the administration process, you should have great interest in at least having a basic understanding of the administration process because it will help you make better decisions in your planning. So even if you're not particularly interested in the administrative process, you should be interested for the sake in administration for the sake of your own planning. Um, the second thing I wanted to mention is just to remind you of the overview of the administrative process. It'll be important to keep these big picture ideas in mind as we discuss the detail. In my view, there really are four steps or four objectives, four things that must be accomplished in every form of administration. What I mean by form of administration, I'm talking about whether a probate is required or not. I'm talking about whether there's trust administration, or perhaps you've organized your estate so that there won't be a need for probate and you don't have a trust. Everything is considered to be what we would deem a non-probate asset. These same four basic steps must still be followed in one form or another in an estate administration. First, you have to figure out who's in charge. If there's a will, that's appointing the nominated personal representative. As a reminder, personal representative is synonymous with the term executor and executrix. Executor and executrix are just gender based terms. Personal representative is a gender neutral term, but they all mean the same thing. So, first, we have to figure out who's in charge of the administration. And again, if you've executed a will, you've had an opportunity to nominate who you'd like to be in charge of your estate administration as part of the decision making and planning you've done in the will. If you've relied on a form of a trust, revocable or otherwise, you have opportunity in implementing the trust to nominate who the successor trustee following your death would be. And so, again, opportunity there for you to control who that person or persons would be. So, first, you figure out who's in charge. Secondly, the process is you have to gather whoever's in charge has to gather the assets, which is to say they have to take control of the assets so they can then go to the next step and have assets from which to pay the bills. The third step then in every administration is paying the bills, paying the creditors, paying the estate obligation arising from the decedent during their life. And then finally, once the bills are paid, the last step really is to distribute the rest of the estate according to either the instructions the decedent had left in his or her will, or in a trust, or if no will or trust, distributing the estate according to the law. We call that an intestate distribution. So those are the four basic steps of every administration, whether probate's involved or not. Figure out who's charged, empower them, gather the assets, control everything the decedent had an interest in, pay the bills, and then finally distribute it according to the will, the trust, or the law. Okay, so that's the basic process. What we want to talk about today and focus on is what if a probate is required. Last time we were with you, we addressed when a probate is required. Today, we're going to assume that a probate is required. You've talked to a lawyer, the lawyers analyzed the basic estate circumstance, and for one reason or another, determined that a probate will be required, which is to say, uh, we need to go to court and commence a probate action. And as a reminder, All that probate is the judicial oversight of the process I've just described. Figuring out who's in charge, gathering the assets, paying the bills, and distributing the remainder of the estate. So it's really just the judicial oversight of that four-step process. That's all really a probate is. Now, yes, there's some notices and some things, some procedural steps that need to be taken, and the court needs to be satisfied that those steps have been taken for the sake of closing the probate or completing the probate. But probate in Washington is really just the judicial oversight of that four-step process. And we're blessed in Washington that we have a fairly streamlined process that really involves very little court intervention unless there's a dispute along the way. There can be a dispute as to who's in charge. There can be all kinds of asset recovery or control disputes, disputes with creditors, and there can be disputes with heirs and beneficiaries about them getting their rightful share from the estate. So there can be disputes along the way. And if there is such a dispute, often a personal representative must be appointed to represent the estate's position in the dispute. And that often, disputes alone will drive the need for probate, okay? So, let's talk a little bit about some of the considerations surrounding the who's in charge element. As I've already referenced, from a planning standpoint, you have an opportunity to designate who would be in charge of the administration of your estate. You do that in your will by nominating your personal representative. Now, let's focus on the word nomination. A lot of people that come in and we consult with in an administration project, they have the impression that because they've been nominated, they're empowered to act, and they're not. They're merely nominated to act. They're not actually empowered to act until we have commenced probate, and as a part of commencing probate, gotten the court to sign an order acknowledging that they're appointed and therefore empowered to act. The evidence of this empowerment is not just the signed court order appointing them as personal representative, but also directing the clerk of the court to issue something called letters testamentary. So in commencing a probate, the authority that we're seeking, the tangible that we're seeking, is a court order that would direct the clerk of the court to issue something called letters testamentary. Now, letters testamentary really are synonymous with letters of administration. Letters testamentary indicate that a nominated personal representative in a will has been appointed. Letters of administration indicate when the decedent died without a will, there's still a need to appoint somebody in charge of the administrative process. The court issues a different form of letter, though it really serves the same functional purpose. That different form is called letters of administration. So when you're nominated in a will to serve as personal representative and the court signs an order appointing you as personal representative, the clerk will issue as your verification, for reasons I'll discuss in a moment, something called letters testamentary, okay? Many people have come to me following somebody's death. They understand they're nominated to serve as the executor or executrix or personal representative. And they'll say, well, I went to the bank and I need to pay some bills and I'm nominated in the will. And the bank said, no, I won't. We can't allow you access to the account. I understand you need to pay bills, but you've got to come back with a death certificate. You've got to come back with letters testamentary and with your identification. And if you'll do that, then we'll recognize your authority. So the only way to get these letters testamentary is to commence a probate. There is no other way to get them. So if a financial institution or any third party in control of an estate asset won't allow you access because they require you first present letters, that's an indication that we must go start a probate and seek those letters from the court. Now, there can be some issues arising over who's in charge that we have to deal with and anticipate in commencing a probate. So, for example, generally you have to be a person. I say generally because there are some exceptions to this, but generally you have to be a live individual to be appointed. Now, if you're a corporation, an LLC, a LLP, or a trust that was established for the purpose and you're licensed and authorized by the state as a fiduciary, you're entitled as an entity to serve as that fiduciary, but otherwise, just a regular corporation, business corporation or real estate holding company is not authorized to serve as personal representative. It's got to be somebody authorized, an entity that's authorized and licensed to provide fiduciary services to be appointed. Persons who are convicted of any felony are disqualified. So sometimes what happens is an individual is nominated in the planning phase in a will to serve. Time goes by, that the nominated individual is convicted of a felony, and then the planning individual dies, and we have to determine and represent to the court as part of commencing the probate whether the person is qualified to act. Well, if they've been convicted of a felony or a crime of moral turpitude, theft, robbery, stealing from your employer, any of that kind of stuff, crime of dishonesty, then you're also not qualified. So the court will only appoint somebody over the age of 18, otherwise mentally capable of serving, and who's not been convicted of a felony or any crime of moral failure, turpitude, to serve as personal representative. Court will not issue letters to anybody who doesn't qualify. Excuse me. Part of the process of commencing probate is to file a petition with the court, and the petition must address the qualifications of the petitioning personal representative. That's the assurance that the court has the petitioning individual is qualified. Furthermore, the petitioning individual has to sign something called an oath. They themselves have to attest they're qualified and will follow the laws of the state and all duties and responsibilities in administering the estate. That's the content and substance of the oath the petitioning party seeking appointment must also present to the court. So every once in a while we do have issues. Sometimes somebody is initially qualified and is appointed and then later becomes disqualified. Well, under our statute, if a person becomes disqualified during their service as fiduciary, then those letters testamentary must be revoked in favor of someone else who does qualify. So there's a whole substitutionary process that must be followed. Now, as I've alluded to, we commence probate by preparing and filing a petition, and we have to inform the court of a variety of things, not only the qualification of a personal representative, but we have to make representations regarding the solvency or insolvency of the estate. Solvency is just a simple representation that the assets will exceed the known liabilities or anticipated liabilities of the estate. When the estate is solvent, the personal representative will, following paying all the bills, as I've alluded to, then have something to distribute to the appropriate heirs or beneficiaries. When the estate is insolvent, that means the assets are less than the total liabilities anticipated, and the personal representative in that situation is effectively working only for the benefit of the creditors of the estate, because there will be no assets available after the debts are paid to distribute to the heirs. In that circumstance, when the estate is insolvent, unless all of the creditors consent, the type of administration is a little bit different. Consent otherwise, I should say, the type of administration is a little different. In an insolvent estate, the personal representative will not be issued what we call non-intervention powers. In other words, when they're working for the benefit of the creditors only, the representative must seek court approval for most, if not all, of the significant acts of administration, payment of bills, etc. When the estate is solvent and non-intervention powers are granted, the personal representative is generally free to make decisions about gathering the assets, paying the bills, and distributing the remainder of the estate without direct court involvement. Now, the court's involved at the commencement of a non-intervention probate, and then it's involved at the end. Per's going to talk a little bit about those issues when he talks about the closing process for the estate. And Sarah's going to address how we deal with creditors, what form of notice, and a little bit about how we deal with creditor claims and resolving those disputes. But commencing the probate, again, involves filing a petition, establishing the qualification of the personal representative, the solvency of the estate. We have to identify the heirs by name and last known address. We have to, and again, as I mentioned, the point is we're seeking appointment of a personal representative, the issuance of letters testamentary to confirm their appointment. We're also seeking the admission of the will and acknowledgement that the will that's been offered is the authentic will. And that is subject to a little bit of procedure about challenge, but at the commencement phase, we're asking the court to admit the will as well. Then once we've gotten the court to sign an order admitting the will, appointing the personal representative, hopefully with non-intervention powers and without having to post a bond for their service, then we go through a phase where we have to send out certain notices. We have to send out notices to the heirs, beneficiaries of the estate, to inform them that the will has been admitted, that a personal representative has been appointed with or without non-intervention powers, with or without bond. And once that notice, and then we typically will publish notice to creditors, which again, Sarah's going to address in a moment. But we need information to establish all those issues I've just outlined. That's part of the commencement process. So key thing to remember, nobody has authority to act in the context of a probate concerning a will until they're appointed by the court and those letters are issued. Now, the next phase, as I've indicated, is gathering the assets. Well, the letters testamentary become the key document needed to go to the bank or to go to the investment broker or to go to any third party and say, hey, I'm now needing to gather control of these assets. Here are I've been formally appointed by the court with the authority to take these acts. Here's my letters testamentary. Here's a death certificate proving death. Now, please recognize this third party as the basis for my authority to take control of these assets. So remember, the only way to take control of those assets, unless you're already a co-owner or otherwise a legal owner of those assets, is to present the bank with those letters testamentary, and the only way to get them is to commence a probate. Okay, so Sarah's going to address a little bit more about the creditor process, and then Per will finish up with the closing process, and then hopefully we'll have a little time at the end to answer any questions that might be presented. Sarah?
Well, we've got about 10 minutes to go, so please forgive me for being brief, especially if we want to leave time for questions. But loosely speaking, as you discussed, one of the primary responsibilities of the personal representative is to deal with the claims against the decedent. So claims must be properly submitted in accordance with either RCW 1142 or 1140, depending on if this is a probate or a non-probate situation. We'll be focusing, of course, on probate. And generally speaking, there are two things that you want to bear into consideration. One is going to be the process that you have to follow and also the time involved. So generally speaking, creditors are going to have roughly 2 years to come and try and lay a proper claim against the estate. A couple exceptions, we won't worry about that today, but generally speaking, you've got about 2 years. And that's a long time to be looking over your shoulder. So Washington has allowed certain processes that are not required, but are encouraged because they can limit that time frame significantly. So the two things that you want to bear in mind in that situation are what is the type of creditor that you're dealing with, and what is the type of notice? What are the tools that we can use? So the court has said there are two types of creditors. reasonably ascertainable creditors, which are defined by RCW 1140.040, which are those creditors which are found with an exercise of reasonable diligence. Essentially, a thorough review of the decedent's correspondence, financial records, checkbooks, places where you would expect to find this sort of information. And then there's everyone else, like the library finds from 10 years ago that maybe we just forgot about, or it might just be me. When you have a reasonably ascertainable creditor, you have to send them actual notice, and or you can fail to do so. But if you fail to do so, we fall back on that 2-year period. Conversely, if you send them this actual notice, and there's language that you have to follow and processes you have to follow under the code, you can shorten that down to the latter of 30 days after the notice, or up to 4 months after you publish notice to creditors. What is publishing notice to creditors? For all creditors, you have a 4-month time period where, let me rewind. You can publish notice in a legal journal that uses specific statutory language and informs everyone that decedent is passed, etc. And in doing so, you can limit the statute of limitations from 2 years down to 4 months. Again, beginning with that first date of publishing. It's a few $100s, you publish 3 times. It's a pretty simple process. And so between those two tools, you can really shorten that time frame. As a practical matter. So while these things aren't necessary, it's really important to consider doing, because as a personal representative, if you fail to do the best that you can be held personally liable. So if you have a claim that becomes due a year down the line that perhaps could have been effectively avoided by utilizing these methods, it can be a problem. It's a whole lot of stuff I want to discuss. I'm a little short on time, so I'm going to pass that on, but I am going to say these processes are incredibly important, and they're also a bit finicky. So it's very important to make sure you're either following this to the letter and you understand what you're doing, or that you find an attorney who really understands this process and can walk you through it properly. Per, I will leave you with the 5 minutes we have left.
Okay, thank you, Sarah. So with the closing of the estate, the first part is to try and make sure that you've got everything done that Matt and Sarah have talked about, as well as distributing assets. Now, you may end up waiting with distributing assets till the very end with the procedure to actually close the estate. But one of the things you definitely want to make sure, particularly if you have a taxable estate, you want to make sure that all the tax returns have been filed and any taxes that are due have been paid. That would include any final return for the individual, because depending upon when they died, they may or may not have filed a tax return for the year preceding their death. There may also be a tax return due for the portion of the year that they were alive if they died in the same year. There may be an estate tax return due if you have, and maybe more than one, depending upon the size of the estate. There could be a federal return due. There could be a state return due. In Washington, the dollar amounts for a taxable estate are significantly less than they are for the federal, but they're still due. And it is important to make sure, and we typically wait with closing an estate until we know that the taxing authority has accepted the estate tax return, and that could take several months from the time that the return is filed. We also want to make sure that creditors have been paid, and also just make sure that there's nothing left undone. Because if the estate is closed, as soon as it's closed, the personal representative loses their authority to act. And if later it is discovered that something was left undone, whether it's a creditor that's there and they have not lost their claim, or if there's some other property that's somehow located, it will be necessary to reopen the probate for the personal representative to be authorized again to serve, to handle that, and then close the estate again. There are several ways to actually close the estate. One of the ones that Matt referred to, if we have to go to court to do that, it could be because we've got an insolvent estate and we just need to do it that way. It may be that we think that there's going to be significant issues raised by someone, and we may know who that someone is, or we may just suspect it. So we may want to have the court hold a hearing, give notice to everyone that they can attend that hearing and raise objections that will be hopefully resolved at that hearing. With the non-intervention wills, very often we can do this without having to go to court. There's a process called using a declaration of completion of probate, and there are a couple of options for that process as well. One is that you send notice to everybody who's entitled to receive that notice, and that would be people who have not yet received everything they're entitled to receive. The declaration is filed with the court, and they then have 30 days from the day of the notice to make an objection. So you're sitting there for 30 days not knowing if someone will object. Either they want to see an accounting, or they have an objection to the fees that are paid or to be paid to the personal representative, the attorney for the personal representative, any accountant for the personal representative, and any appraisers that were used by the personal representative. And that's the only financial information that shows up in that declaration of completion. There may or may not be an accounting that's provided to those beneficiaries just prior to closing. And that will really depend upon the estate, the number of beneficiaries that are involved, how well they have been advised or informed by the personal representative of the progress of the estate and maybe some of the expenses that the estate has incurred throughout the course of the administration. The other alternative is what's known to, you still use the declaration of completion, but you use a waiver of notice. And in that case, if everyone who is entitled to the notice signs it, then as soon as the declaration of completion and all the waivers have been filed, there is no 30-day waiting period, and the declaration serves as a court order. And as soon as it is filed, the case is completed and the personal representative loses their authority. Distributions will usually, if there aren't interim distributions, they will also take place in connection with the closing. And that could be tricky depending upon whether you think that there's going to be objections using our first option of the declaration of completion of probate. It may be necessary to hold on to some of those, because if there is an objection, the hearing will still entail costs for the estate that have to be paid. They will be paid before there are distributions. So in a very small nutshell, that's how we can close the estate, either with or without court involvement. And like I say, typically what we see is no court involvement because we can use the declaration of completion of probate process. So with that, I'm going to have to turn it back to Matt, and we'll see if we have any questions.
Yeah, Sarah, let's take about 5 minutes or so, if there are questions, to try to address those.
We have one question, which is, as executor of a poorer will and trustee of the subsequent trust, how does the probate affect the process?
Yeah, great question. So the way I typically discuss this with clients is when there's a revocable living trust, I think of the revocable living trust as the primary estate planning tool. Typically, we also have a will, but it's a little different than the will that you might be thinking of, because usually the will makes the trust the primary beneficiary of any asset not owned by the trust. So the trust has the jurisdictional authority to control only and dispose of only the assets it owns. If a decedent has implemented a trust, funded a trust, and then oftentimes lives a lot of additional life, they commonly acquire assets that they're not subsequently transferred into ownership of the trust, so that at death, their estate is a combination of trust assets owned by the trust and some assets not owned by the trust. If the assets not owned by the trust constitute real property or financial assets, often the only way to get those assets retitled into the trust is to commence a probate, have a personal representative appointed, obtain letters testamentary so that either a deed or can be used to transfer real estate into the trust so the primary planning can then be followed, or a financial institution will just insist before they'll release control of monies held in various types of accounts that you present letters testamentary, which means, again, you have to go commence a probate to get those letters. So the concept then is if there are probate assets subject to probate, that need to go because of the terms of the will into the ownership of the trust, and then the trust would be looked at and followed to accomplish the ultimate distribution. Probate can be required to get those assets into the trust, so then the trust can be administered without probate. Often a revocable living trust is executed for probate avoidance reasons, but when the trustor neglects to transfer everything into the trust, and sometimes it's not a matter of neglect, sometimes it's intentional for one reason or another, but when assets are held by the decedent outside the trust, a probate may be required to get them into the trust so the rest of the plan can be followed. So that's how they work.
And we have one more question. This is from Eli, a business valuation forensic accounting professional. He is interested in how the solvency of the estate is determined and who makes that determination.
Yeah, fair?
Sure. Initially, what we ask for is kind of a ballpark figure of the value of the assets in the estate, and as well as a ballpark figure of what kind of debt, such as mortgages, any other kind of loan, maybe credit card debt. But we don't worry about an appraisal at that point, because it may be necessary or appropriate to get the probate started as quickly as possible. And an appraisal may take too much time to do that, and some rights may be lost if we have to delay the opening of the probate. So it's really a best guess by the personal representative as to those values. And very often, even in the probate pleadings, my practice has been to somewhat understate a little bit the assets, or maybe I'd rather understate them than overstate them, and make sure that we got a fairly good handle on the amount of liabilities, because the court will really only look at what's in that petition for what's the value of the assets and what's the value of the debt, and see that the assets exceed the debt. I don't think I've ever been asked a question by a judge or a court commissioner in opening a probate, well, how do you know these values? It's really a best guess. Real estate, you can probably use, if you got a recent appraisal that was done for maybe a refinance of the house within a year or so, that may be more accurate than an assessed value. But it becomes important during the course of the probate as well that it may be necessary to revise the information to the court, because if it turns out you were pretty sure it was solvent, and now information that you did not have at the time that the probate was started, but it shows it may be insolvent because, for example, there may be a claim out there that the personal representative did not know about. And it turns out to be a significant claim that, if valid, renders the estate insolvent. The court has to be advised of that, because that would, making it an insolvent estate, as Matt mentioned, now we have to go to court intervention, and that's going to change a little bit how we do the probate.
Yeah, thank you, Per. We've got maybe time for one more question.
So this is a clarifying question from before, which is, does a pour over will negate the probate of the first trust?
No. The trust administration, again, will concern the assets owned by the trust. If a decedent dies with assets owned outside the trust, a probate may be required to transfer those assets into the trust, so the trust will dictate the distribution and administration of the estate. So if there are no assets outside ownership and control of the trust at the time of the decedent's death, there should be no reason for probate, because the trust administration will not depend on the appointment of a personal representative because the trustee nominated in the trust to serve following the decedent's death will, by virtue of the trust ownership, be fully empowered to control all the assets. So if the trustee is fully empowered to control all the assets, to pay the bills and make ultimate distributions according to the trust instructions, there will be no need for a probate. If, again, the trustee does not control all the assets, because not all the assets are owned by the trust, then a probate may be required to get the assets under the trustee's control. Hopefully that's clear. Listen, let me wrap this up. First of all, if there are any other questions, feel free to contact me or Per or Sarah. We'd be happy to answer the questions further and follow up. Thank you for joining us. Don't forget, the administrative side is the implementation of the careful planning you did during your life. To have a basic understanding of how the estate is administered will assist you with your planning decisions. And finally, I would say, you're not required to have a lawyer, but we've touched on to do an estate administration or even to commence a probate. There's no law that requires you to hire a lawyer to do those things, but some of these procedural aspects, as Sarah and Per have mentioned, are a bit technical. And if you're concerned that hiring a lawyer will add unnecessary expense, at least consider consulting with a lawyer so you can be coached, if not represented through the process. Again, we invite your questions. We're here to serve and happy to help. And thank you for joining us.